Mr. Ponton, I believe you have a filter turned on in the video settings.
Can you hear me, Judge?
I can hear you. I think it's a filter.
I'm prepared to go forward with it. I'm here live. I'm not a cat.
Welcome back, everybody. Mark Breyer, the husband and wife law team, a real-life trial lawyer. What? Not these people who play lawyer on the internet or play lawyer on billboards. Actually, you know, I go fight for people. So today we're going to do something a little bit different. Now, before we get into that, let's get into the most important thing. 95% of you are failing me because you're watching these videos and you're giving comments, which I appreciate, and you're following, which is awesome. Why are you not subscribed, y'all? What are you waiting for? Go ahead. Let's do that, and then we're going to get into this. Now, here's what we're going to do a little bit different today. I'd love to get your comments in this. Court hearings ever since COVID have gone online. Not all of them, but a lot of them. So we're going to actually now see into real court hearings together, see some things that happen, and I'll give you my take as someone who's been in these many times. Oh my goodness, the next video is Judge Simpson from Washtenaw County again.
There's a lot of Michigan lawyers in this for some weird reason.
What is going on in southeastern Michigan, everybody?
Well, Michigan has Wolverines.
So she can go ahead.
I'm requesting permission to practice under Michigan Court Rule 8.120. We're regulars.
Oh, listen, they also become regulars. I like that. They appeared once and now they're a regular.
We are happy to brief and explain our calculations.
No, this is why you should have gone to the University of Maryland. You don't have to brief everything. I just need an explanation. Everybody from Michigan wants to brief something. It would serve the tenant's benefit if there were leprechauns and pots of gold.
That's why I was saying that we think it's two separate issues.
I know, but you were saying it like the University of Michigan way, which was taking a really long time, and I don't have that much time.
I'm happy to go through the numbers. I know them quite well.
Oh, don't. No, you're going to go through them in the Michigan way. It's going to be a lot of numbers.
Just one final point I'd like to make on this issue is that...
Oh, dear goodness.
All right, let me just stop you and tell you a story. I worked for Ada Montgomery when I was in law school. And Ada did a lot of work in the city of Detroit, and I worked for her for a summer, and she taught me so much about the law in the summer. And she used to say the same thing because she had to deal with the University of Michigan, I'm holier than thou in court, and she would shred them. She would shred them. And let me tell you how. They would file these 27-page briefs with 18 attachments, and Ada would file like a 4-paragraph response and win because she actually got to the point. I feel a little bad for the student, even though the student chose to go to the University of Michigan, so really isn't that on her. But I do feel bad for her because she's there, she's prepared, she's doing what she's been taught to do. But this is the real world. And the judges don't have time for you to pretend like it's a Supreme Court case because they have a really, really busy docket. They got to go person. You should have seen Ada shred these big firm, white shoe, I'm better than everyone lawyers over and over and over again because she was actually like, well, here's the actual issue, Judge. Here's why we win. Granted, it was amazing.
No, go ahead. Where did you say you were from?
Boston.
Yeah, okay. This is an Eastern thing. Go ahead. I look like, and I am. I'm just a little country judge trying to do a little bit of justice.
And I say this with no bias whatsoever. Nobody who cares about themselves, cares about others, connects with people. Nobody should go to the University of Michigan. Because they teach you the things that don't matter in real courtrooms, in real life, and instead fill your head with just arrogant nonsense, no matter how well-intentioned you are. Go green.
Then we'll bring this fool in.
Oh!
Good morning, sir. What's your name?
Me?
Yeah, you. Yes.
Nathaniel Saxon, sir.
Your name's not buttker 3000, you yo-ho. Logging into my court with that as your screen name.
Why
We'll
would that?
discuss that in a little bit. What kind of idiot logs into court like that? What's your name again?
Nathaniel Saxton, sir, but I don't believe that I typed anything like that in.
Well, that's what it says.
Why,
We'll
I
discuss that in
apologize.
a bit.
That should not
Yeah,
be.
you should. I'll put you in the waiting room. You can sit in limbo for a while.
All right, let me just say this. One, that's hilarious. And two, come on, man. The judge, you could see from his reaction, he probably had no idea who typed that, which of his kids did that, why they did it, were they messing with him, was it a prank, someone using his Zoom. He was like, I didn't type anything like that in. Is it possible he was being disrespectful to the court? It's possible. Is it probable? No. He had no idea that was about to pop up on his Zoom screen. And now we just attack the man. I get it. Listen, it's a judge's courtroom. You do have to show respect in the courtroom. But what about things that you don't know with technology? So I know, go ahead, comment. Go ahead. I'll give you a second. Go ahead. Comment on what I just said. Now understand this. I'm not saying he shouldn't make sure that before he goes on with the court, he's not wearing the right stuff, presenting himself well, or that he knows the technology. But we can show a little grace to someone who probably had no idea what was going on or how that happened without ripping him as if he did. You could at least potentially ask the question, how did that get there? Why is that there? That seems disrespectful. I want you to explain it to me. Maybe we would have got an explanation that would have made it clear that he truly, you can tell, has no idea what happened. I have no idea. My kids use Zoom with each other. I don't know.
Mr. Ponton, I believe you have a filter turned on in the video settings.
Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
Hey, generally speaking, technology-wise, lawyers are behind the curve. And so this is the kind of thing that would happen to a lawyer. He doesn't even know what to do. He's asking his assistant. His assistant has probably been by his side for 38 years. She doesn't know how to do it, or he doesn't know how to do it. And now he is appearing for a hearing that might have a huge thing. This could be, for all I know, I don't know yet, this could be over a $4 million property dispute, and the man looks like a cat.
Have you ever had something like that happen?
Never. I've been on countless video conference hearings since COVID started, and I've never had anyone show up as a cat. There have been problems. We've tried to get witnesses in the courtroom. They can't connect, or only the audio connects. We try it out the day before, it works. We try it out before the jury walks in, it works. Jury walks in, try it out, it doesn't work. So we've had issues, but never cat issues.
Does your appearance in court count only if your camera is turned on?
So that's up to the judge. The judge has the power to decide if your appearance with your camera off is okay. Most judges will not allow it in most situations, but in that situation, I think the judge would be more likely to say, turn off the video and just appear, your voice is good enough. Because before COVID, it was less common, but it happened somewhat regularly that we would have telephonic hearings. So that wasn't unheard of at all. So everyone was just voice. And then in those was hard because every time you spoke, you had to say, in my case, this is Mark Breyer, and then you would speak. And someone would forget to say, excuse me, can you please say who's speaking for the record? So by moving to video conference, you don't have to say your name every time, and it's way better, and you can see what they're saying. And so there's a lot of advantages.
Mr. Garrison, can you state your name for the record, please?
DNS Garrison.
DNS, turn your camera off, please.
Yes.
All right, Mr. Garrett, oh no, come on, man. I'm out. You don't have a shirt on. I'm putting you out.
Give me 1 second.
No, I'm not giving you a second.
Ridiculous.
That says defense attorney? Hold up. Wait a minute. Let us put some boom in it. Listen, the judge is right. You're showing up in court. The judge is allowing you to appear by video. You can't have no shirt on. You're not talking to your friends. What are you doing? However, if this video is right and it said defense attorney, and this is a criminal case and that's a defendant, your own lawyer has to keep that internal dialogue internal because it is ridiculous. And you need to tell your client it's ridiculous. And now you make the lawyer look bad. That lawyer's got to represent you and other people. When your client shows up like that, it's going to make you look bad. You're going to feel some type of way as the lawyer. But probably defense counsel, if that really is defense counsel, wishes she hadn't said that out loud because it's her job to advocate for the client.
Haywood's bond was set at $250,000, which he has not been able to post. So today he appears from the Washtenaw County Jail. The case was scheduled for a probable cause hearing, but Haywood's attorney, Erica Julian, has a problem.
Good morning, Your Honor. I filed a motion to withdraw due to a direct conflict of interest regarding a witness or potential witness in this case that I identified after meeting with Mr. Haywood. As a result, I am unable to continue to represent Mr. Haywood. I would ask the court to permit me to withdraw.
Okay, notice in the motion.
Let me just break this down. Lawyers have ethical requirements. So a conflict, there can be a lot of conflicts, but there are times where if you continue with the case, you could lose your license. So our job as lawyers is to make sure that we honor the rules so that we don't have conflicts. Now, a lot of times they are super hazy and sometimes they're clear, bright lines. Like interestingly, the number one thing lawyers call their state bar about is this a conflict? But it's like number 14 on things that actually get lawyers in trouble, because as lawyers, we can all get concerned about things that aren't actually conflicts or they're mild conflicts. I don't even know the story yet, but for the lawyer to be concerned makes sense. It's not about the lawyer. The lawyer has ethical responsibility.
That I don't have the witness identified or the person identified.
Your Honor, if I identify the conflict who is not listed in the police report, he could be charged with crimes, and I've previously represented him. So I'm unable to provide additional information, which would result in discovery to the prosecutor.
Haywood's attorney finds herself in a bit of a legal pickle. She's aware of a witness in this case that the police have not identified yet. Trouble is, the person's a former client of hers. So identifying and thus potentially incriminating them would be a conflict of interest. But unless she does identify the potential witness, the judge may not be able to make a ruling.
I mean, I can't do it this way, Miss Julian. I mean, I have to have some indication as to what the conflict is.
Why? You know how many lawyers are ready to take over this case? So unless there's some court rule in the state of Michigan that would not allow a judge to grant a lawyer the withdrawal, and I doubt that's true because lawyers could have to withdraw because they're leaving the practice of law, because they had a vacation that came up out of nowhere, because someone in their family got sick. There's innumerable reasons why someone may need to withdraw. This is a conflict, and she's saying, I can't throw someone in prison so I can get off this case. Well, the only reason I'm getting off this case so I don't put someone in prison because the police have to do their job, I have to do my job, the court has to do its job. I like Judge Simpson. We keep seeing Judge Simpson. Seems very down to earth, no BS, the kind of judge that, you know, like, look, let's get some real people who actually know the law, understand what's going on. And Judge Simpson feels that way to me. But so far to say, I can't let you off. So what is she supposed to do? Stay on the case? She can't stay on the case. So what is she gonna do?
She just told your stupid ass.
Haywood jumps in to defend.
Oh, this just got so much worse. I do not think that he realized that he was mic'd. Just the tone he used when he said it. He was like saying it to himself, like the way you talk at a screen. This just got so much better and worse.
She just told your stupid ass.
Mr. Haywood.
No, you didn't. Bond revoked. We're done.
With his bond revoked, Haywood will be staying in jail until his case is resolved.
Mr. Judge
Bond
Simpson,
revoked. Bond
I'm unable to
revoked. He will sit. This
Yes, Your
matter
Honor.
is adjourned to September 1st. Bond revoked. I'm done. You go talk to your client. He'll never address that court this way. His bond is revoked.
Yeah,
You're
but
still
Judge,
his
I
attorney.
can't talk to the
Motion
client. I have a
denied.
conflict with the client.
Thank you.
I want to start by saying the judge had every right to do what the judge did. The judge feels very straightforward with it, gets it the way we want judges to be. But you just ended that hearing because you were mad. You had a right to be mad. You revoked bond. You had a right to revoke bond. But you left this lawyer on the case. Go talk to your client. Judge, I just told you it can't be my client. So now she goes, talks to the client. She's talking to a client with whom she has a conflict. She needs out. The judge won't let her out. She doesn't go talk to the client. Now he is supposed to be getting representation from a lawyer that can't represent him. I know why he was mad. He had a right to be mad. I'm really not sitting here saying, I get it. He wanted to end that hearing because don't you ever speak to a judge that way, and that's correct. Can't do that for the lawyer. Woo!
Original judgment would stand. Is someone kayaking during their hearing?
Yeah, sorry.
Well, I'm glad this was really important to you, but we'll get to you in just a moment.
It doesn't matter if the court allows you to appear by video conference. If you ever appear in front of a judge, remember the power the judge has. Respect that power. No matter what you think of the process, no matter what you think of the situation, this is insane. It's not a phone call with your lawyer. And even that you should probably take more seriously. Like, what?
Mr. Harris, are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
Okay, bad start, by the way. You're literally making the judge who holds the power over your life because of the situation wait for you while you make everyone in the courtroom wait for you.
Stationary?
I'm pulling
Yeah,
in
bad
right
start.
now at this second. Yes, I am.
This is a driver while license suspended,
That is correct, Your Honor.
and he was just driving. And he didn't have a license.
What a great moment. This is when he's like, oh, that was a bad idea. The judge didn't even wait to hear both sides. Some judges would be like, hey, it's the job of the lawyers to raise this. My job is to decide the problem. This judge just got right to, what are we doing here, Mr. Defendant?
Oh.
Is with the charges, Your Honor, yes.
All right, so first of all, let me just defend this man for a hot second, okay? He was charged with driving while his license was suspended. That does not mean it's still suspended. He could have gotten it unsuspended. That doesn't get rid of the prior charge. So this judge is assuming it's still suspended. The judge doesn't have that in front of him. That's not part of this case. This judge is taking a leap. And arguably, as the lawyer, you could say, Your Honor, that was the charge. There is no such charge here. He has not been arrested. He has not been accused. You are not the officer, the police officer. You are not the prosecutor. You are the judge. It's not the way I would say it, by the way, to the man in the robe. If you get charged with driving with your license suspended, you get your license suspended, you are still charged with this crime. You can now drive. But based upon the way Mr. Harris looks right now, I do not think that's the truth. But I'm just saying it's possible.
Anything is possible.
No, I'm looking at
Yes.
his record. He doesn't have a license.
Or I could be wrong, and the judge knows he still doesn't have a license, which would still be like, Judge. Yeah, that's a problem, Judge. But I would advocate. I mean, I would say, Your Honor, there may be a time they would have that. It doesn't matter. When you go to court, this is a very important moment, because even if you did nothing wrong, these people hold a lot of power. The system will run you over. You can be totally innocent, and the system may run you over. People are in prison today who didn't do it. The system is a huge, massive system, and justice is not always done. Don't give anybody any reason to come at you when you're dealing with anything judge court related because of the power they wield at that moment. All right, this is about to get interesting.
He's suspended and he's just driving.
That is correct, Your Honor.
Whoa. We don't really know if he was driving. Let me tell you why. He said, I'm pulling into the spot in the doctor's office right now, which means he might have been in a big parking lot the whole time. We didn't see if he was on a street, and he may be allowed to drive the vehicle on private property. There is a good chance that's true. So we're just jumping at Mr. Harris here, and everyone's just agreeing he's guilty, and we don't know. We may suspect based upon Mr. Harris's reaction at the moment, but I'm saying we didn't see him on the street, and he said, I'm here. So you know what he probably did? Ever since his license got suspended, the car has been parked at the same spot. So once a week while staying on private property, he just drives the car around to make sure there's no buildup in the engine that ruins the car. So that's what's going on here as far as we know, and he is not charged with that, Your Honor. Can we get back to the reason we're here? Can you imagine what Mr. Harris is thinking right now? Please don't speak. Don't do it. Don't raise your hand. Don't, whatever you say, please don't say it. I don't say a word. Don't say a word. Let it go. Let the lawyers do their job. What you say is an admission. What they say is not. Let the lawyers handle it.
Hello?
No, don't do it. Please don't do it.
1 minute, Mr. Harris.
Because one of us go in and we all go through it. All right, don't do it. There's an 87% chance if he speaks now, it will end up worse for him in the long run.
I don't even know why he would do that. So defendant's bond is revoked in this matter. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
I'm just saying. We don't know that he did it. We don't know he was driving around southeastern Michigan. We don't know what he was doing in Washtenaw County. We don't even know if he was in Washtenaw County. Maybe he was in Europe and his license is not revoked for Europe. I mean, I'm just saying there are possibilities here, and we can't just assume that he is guilty beyond a reasonable doubt. I'm throwing out reasonable doubt, right? All right.
The judge came ready to set the record straight with Corey Harris, who has claimed that he thought the suspension on his driver's license was removed 2 years ago.
That court and its friend of the court did nothing wrong. His driving privileges were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it.
The judge said Harris never paid his clearance fees with the court or the Secretary of State to lift the suspension, but that's not all.
He has never had a Michigan license.
We asked Harris yesterday if he ever had a valid driver's license. He claimed he didn't remember. Do you ever recall having one? Having a driver's license?
I knew I had a permit. I knew that.
A driver's permit or?
I believe. I don't know. I can't say yes and I can't say no.
And that's odd because the Pittsfield Township police officer and prosecutor said during that October traffic stop, Corey Harris knew what was up.
At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license.
Hold on, can I just say something here? He was not accused of driving without a valid license. He was accused of driving on a suspended license. They're trying to say, no, well, you never had a license. Well, then I guess it wasn't suspended, was it? You can't suspend what I don't have. And if you follow this whole thing in the clip, what did they just say? The suspension of the license he never had was removed, but he didn't pay his court fees. So that's it? So we're gonna send people to jail because there was a lack of clarity on whether he had to pay his court fees. All right, let's get into this a little bit, but I just want to point out that not having a license and a suspended license may be different depending on the laws of the state of Michigan here. I don't know. Let's find out.
He has a warrant for his arrest.
Corey Harris was taken into custody for what appears to be a 9-year-old bench warrant out of Allen Park.
Oh, come on. Come on. Come on. A 9-year-old bench warrant out of Allen Park. So let me explain a bench warrant versus a regular warrant. In a regular warrant, they're coming at you for something serious. Okay, they will come find you if you don't show up. You're putting up money, you may put up your house. A regular warrant, a non-bench warrant, you did something really serious and they're coming at you. A bench warrant is you didn't pay a speeding ticket. 9 years. 9 years ago, I didn't do something. And now on TV, I'm already having enough trouble. Now on TV, I'm pulling you back. I'm not saying the judge had a choice. I'm not being critical of the judge. I guess I have a problem with the system a little bit. 9 years. If he's been out there 9 years, not causing any physical damage or harm to someone, does he really have to go to jail? Couldn't he, after 9 years, couldn't we agree on something other than that? He brought a lawyer. He showed up in court twice. The time before this, he showed up in court when he got busted for driving on a license he didn't have, allegedly. I'm not letting him off the hook, but it feels like a very harsh response. And I know, go ahead, comment. I know what you're gonna comment. Hey, justice, justice, justice. I agree, justice. I agree we all have to do the right thing. I agree there are laws. I hear all that. But there are times where the result is harsh. He might have gotten a speeding ticket 9 years ago, moved, didn't even know they were still coming at him. All he got was something in the mail that never made it to him because someone who lived there was like, oh, I'll get it to him later and forgot about it. It's been 9 years. And now he's getting taken to the back on TV again. Woo! That's why I do personal injury law, everybody, because there's less of that kind of like silliness. It is a little more straightforward, more complicated in some ways, but the issues are complicated, but what the issues are straightforward. Your client doesn't usually go get taken back for a 9-year-old bench warrant.
On the iPhone, I just let you in the room. Good morning to you. Start your name. And
Asia Outerbridge.
And turn your camera on, man. Asia who?
Outerbridge.
And why are you so late?
Because I have a paper right here that shows my court started at 1 o'clock. But then when I called, right here, if you can look on this thing right here, it says 1 o'clock.
I don't see one.
Okay, rule number one, do not use evidence that directly contradicts your position. That's rule number one. I know it's a complicated one, but just keep it in mind.
Maybe
Like I saw 9 a.m. It looks like I saw 9 a.m.
I had 1 o'clock on one of those papers.
You just showed me a paper, Miss Outerbridge. That
yes, I
said
did. Right. So when I called,
no, we can't talk at the same time.
Oh my goodness, you're talking over the judge while making a peanut butter and jelly sandwich. What are you doing? It's.
Well, I apologize for being late. Excuse me. You asked me a question. I'm just trying to answer it.
I know. Put whatever you're trying to prepare down.
I'm trying to feed my daughter.
Get your clothes, you gotta put your properly dressed on. I am
properly dressed. I have on a t-shirt. I am properly dressed.
Is that a robe?
It's the problem, sir. I'm not even doing that. You asked me a question. I'm answering. My daughter is sick. I had to keep her home from school. I'm just trying to feed her. That is
That's
it.
understandable, but you're in court.
Ms. Outerbridge, Ms. Outerbridge, I'm sorry that your daughter is sick, but again, you're in court.
I want you to know something. Judges have a lot of power. See the way he leaned back, tried to collect it. He didn't have to do that. You may say he should. I think it was good that he did it. A lot of judges, they get that black robe on and now they think that they can treat people any way they want while it's on. He didn't do that. He got upset. She wasn't listening. She clearly doesn't understand the right way to appear in court and the respect to show to the court. That's all right. Now the judge is trying to go, let me try to get this back. He doesn't have to do that. So remember, whatever happens next, he never even had to do that. He could have said, you're going to come in right now, bring your daughter with you if you have to, find someone for your daughter. You are 4 hours late. You just told me something that isn't on the paperwork. You're making a sandwich. You're talking over me. If you're not here in 4 hours, I'm going to send the police out to arrest you. He may have been able to do that.
Okay, and we're going to treat it as such. I asked
Okay,
you.
I'm properly dressed.
No, don't talk really talk.
I have on clothes. I have on clothes. I have
Fine,
on
Ms.
clothes.
Fine, Ms.
I have on
Outerbridge.
clothes. I have on clothes. What?
Ms. Outerbridge.
Yes.
Let me just, now listen, I'm gonna explain to you how this goes, okay? When I talk, you don't talk, okay? If I ask you a question, then I just asking you a question, I need an answer from you. When I wanna know something from you, I'll let you.
Now, here's what I would love to know, because I don't know this judge. I'm not sure. Is he a judge you think that generally is calm and he's just upset with the way she's come at him? Or is he a judge who, I'm the judge, do as I say? I'm not sure. It'd be interesting to hear from people from Detroit who know the judge, because I could see it either way. Let's see how this unfolds.
You came in here earlier, you came super late. Now, all I asked you was why you were late. You told me that you got a notice that it said 1 o'clock or something like that. And you held the notice up and you showed me the notice. Whether that was the notice that you got, I don't know, but the notice that you showed me was 9 a.m. Now, after that, everything fell apart. You come in court with a robe on. I want you to be at least presentable. I didn't ask you to put a suit or your Sunday clothes on. I want you to be presentable. And I want you, when I'm talking, this is my courtroom. You don't talk. And I'll give you a chance to speak if I need to know something from you, like I asked you that. So those answers that you gave me were your answers. And now you want to get upset with me because I'm trying to keep some sort of decorum in the courtroom. Now you're rolling your eyes.
I'm not rolling my eyes. I'm looking at my daughter.
You rolled your eyes.
I'm looking at my daughter. Okay. Okay.
There we go.
Okay.
There we go again. There we go again.
Don't you wish you could see if she rolled her eyes?
I'm the one that can dismiss this case or not. Come back in the screen, ma'am. Don't go rolling your eyes and under the screen now.
Sir, I think you're being very biased because I'm quiet. I'm not even trying to be argumentative. I'm here. I explained why I was in my robe and I explained why I was late to the court. You are still nitpicking. We already had a talk about it when I came back in. I said, okay. And I left it at that.
I just want to say, she's frustrated. She just wanted to be heard, and I get it, because now this thing's been going on all day. But this is not an even power situation. The judge has the power. Even if the judge is wrong, the judge has the power. So what is your goal? Is your goal to argue with the judge or get off? Even if I get it, and she's totally frustrated, and she just wanted to be heard, and this judge wouldn't let her talk, I get it. Even if she had something else that said 9 a.m. and something else that 1 p.m., I get it, right? I understand. But right now she's giving it to the judge to correct him in a situation where all she has to do is say, okay.
I'm not trying to argue with you. I have a 3-year-old. I have a 3-year-old jumping around over here. I'm just trying to pay attention. That is all. I'm not rolling my eyes at you. I don't have an attitude at you. If you're going to be biased towards the case, because you're upset with me about being late, then maybe I should get a new judge. But I'm not trying to argue. I'm just trying to get the case over with so I can go on about my day with my sick daughter.
Trial date, July 1st, 2025 at 9 a.m. Best of luck to you, Ms. Outerbridge.
Woo!
Let's look at it from the perspective of the defendant who was charged with something, who was stuck at home with a sick kid jumping around. And all she tried to do was appear. She got the time wrong somehow, whether she got it wrong intentionally or got it wrong accidentally. Let's assume she got it wrong accidentally. And let's assume the judge was a total jerk to her. You know what the judge just did? Did not dismiss the case, made her show up for a trial, which is way worse. Why? Because she wanted to be heard, which is an understandable human emotion. This is the judge. And if she just would have let her lawyer do her lawyer's job, she might never had to show up again. What is your goal? When you show up in court, your goal is justice. Your goal is the best possible outcome for you. Let your lawyer do the job lawyers paid to do. Do not ever, ever do things that you know are going to aggravate the people who have the power to make the decision against you.
You operating a motor vehicle, ma'am?
Am I operating it? No, I'm just sitting in here now.
I said, were you operating? Listen, if you don't sit still and pay attention, then you're gonna get put back to the end of the line, okay?
Because I didn't understand what you said. I said, I'm not.
No, because you didn't understand what I'm saying. All right, pass the matter. I'm tired.
So I can leave, or I'm just waiting for you to come back.
You're just waiting. You're just waiting.
Some bullshit. This is crazy.
All right. All right. Okay. Now you're coming down to the courthouse. All right. Now I want you to make your way down here now. I'm gonna show you some bullshit.
I think the judge was right at first. He definitely wants respect in his court. He makes it pretty clear by his demeanor. He has a right to do that. It's his courtroom. He can be a laid-back judge. He can be a law and order judge. He can do it any way he wants. I do believe he was right that she wasn't really taking it that serious. However, when you're the judge, be fair. No matter how frustrated you are the pillar of the system. You are the judge. You are the court. You are the law. That's why we call it. It's not just judge. He is the court, is the way we refer to it as lawyers. I get his frustration. Once he goes off the record, if he wants to say that, he can say it. I think it's a mistake to say it on the record. End of the world, no, but it's a mistake to say it on the record. Don't lower yourself down to someone who's not paying attention.
Today, Lane is requesting to waive his right to a probable cause hearing and have his case sent straight to circuit court.
By the way, this should be super easy because in a probable cause hearing, what they're doing is they're saying you don't even have probable cause. This doesn't even go to trial, right? Doesn't even go to court. We're good. If you waive probable cause, you're going to court. There's a lot of reasons why criminal lawyers do it one way or the other, but that's what's going on. This should be the easiest hearing ever. All he's got to do, show up, say we waive probable cause, things set for trial, we move forward. But I'm watching it and my team's making me watch this, so something's about to happen.
Everything seems to be going as planned until the judge asks the prosecutor if he also agrees to waive the probable cause hearing.
People also waive their right?
Your Honor, I'll agree to waive, but I do want to make a statement on the record. It appeared that earlier in this time block that Mr. Lane was rolling a blunt and might have been smoking.
Hold on. This is BS. You know why? Yeah, we see him take out the paper. We know papers are often used for blunts. That could be tobacco. We have no idea what that man is putting in that rolling paper, but we're just gonna assume now, beyond any reasonable doubt, you can go to Europe right now and see people roll up a cigarette in a hot second with tobacco. This man may like his tobacco in paper that other people like to put their weed in. We have no idea. And now we're just gonna assume. Now, please, Mr. Lane, now that I just said that, do not admit anything. Please say nothing. Now he's just smoking that cigarette.
He continued smoking during the session and flaunted the blunt up close while Judge Simpson was handling other cases.
Nope, he flaunted something in the cigar paper. We don't know what it is.
Court staff took notice and informed the prosecutor.
Your Honor, given that information, I guess we need to adjourn the PCC so Mr. Lane and I can speak further before we wait.
Yeah. I thought that might be wise. Mr. Lane, you understand what's happening now?
Just say yes. Good job.
As part of his bond conditions, Lane is also supposed to be taking regular drug tests.
When's the last time you tested?
2 weeks ago.
You were supposed to be testing 2 times per week.
I tested back to back.
Okay, but have you tested this week?
No, sir.
I'm also going to order that you're to report to community corrections.
Oh man, Judge Simpson making you come in now, which could disprove my attempt to create a reasonable doubt as to what he was smoking. Come on, Judge. That was pretty good on the judge's part, but not so good for my theory, probably.
But as the judge moves on, Lane lingers on the call and lets out a laugh.
You keep laughing, Mr. Lane. I don't think you want to do that. Not with me. You better take yourself off before you think things are too funny. Thank you.
I wasn't laughing at you, sir. I wasn't laughing at you, sir.
Yeah. Thank you. Court calls case, people versus.
I just want to point something out. He may not have been laughing at the judge. One of his friends, someone in his family, might have been telling him how stupid he was, and he laughed like, I can't believe I was that dumb. If you watch all these videos we've watched just now, here's the thing. It's why a courtroom's designed like it is. A courtroom is designed to be impressive. That's why it's like that, right? It creates a seriousness.
Whoa, whoa, whoa.
When you're sitting on your couch, sitting in your car, whatever, in your kayak in one case, it's easy to kind of forget that it may be on my phone, but I'm coming into a courtroom with all the same power and everything else. Try to just plant a seed for yourself when you see this. You, someone you love, they have a court appearance. Dress up like you're going to court. Show the system respect. Do it in a place that's quiet. Understand that everything you do, in effect, is being watched and recorded, even more than in court in some ways. So a lot of people make a lot of mistakes because they let their guard down because of their situation, which would not have happened as often if they were in court. All right, now, if you liked seeing all these courtroom videos, see this? Right here. It's another courtroom video. Click that. Now, in the meantime, do me a favor. Comment. Let us know. You want to see more of those? What else do you want to see a trial lawyer actually comment on? Don't forget to follow and like, and we will see you next time from the Husband and Wife Law Team.